Hi sir, good day. I am Jane Belignacio. I'm going to recite the Rule 128, 129, 130, and 131. Rule 128, Section 1. Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section 2. Scope. The rules of evidence shall be the same in all courts, in all trials, in hearing, except as otherwise provided by law or these rules. Section 3. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and not excluded by the Constitution, the law, or this rule. Section 4. Relevancy collateral matter. Evidence must have such a relation to the fact in issue as to induce belief its existence or non-existence. Evidence collateral matters shall not be allowed except when it tends in a reasonable degree to establish the probability or improbability of the fact in issue. Rule 129, Section 1. Judicial notice. Judicial notice when mandatory. A court shall take judicial notice without the introduction of evidence of the existence and territorial extent of state, their political history, forms of government and symbols of nationality, the law of nation, the admiralty, and the maritime court of the world, and their seals, the political constitution and history of the Philippines, acts of official of acts, legislative, executive, and judicial department of the national government of the Philippines, the law of natures, the measure of time, and geographical division. Section 2. Judicial notice when discretionary. A court may take judicial notice of matter which are of public knowledge or are capable of unquestionable, demonstrable, or ought to be known to judges because of their judicial function. Section 3. Judicial notice when hearing necessary. During the pre-trial, the trial, the court, motu proprio, or upon motion, shall hear the parties on the propriety of taking judicial notice of any matter. Before judgment or appeal, the court, motu proprio, or upon motion, may take judicial notice of matter, shall hear the parties thereon if such matter is decisive of a material issue in the case. Section 4. Judicial admission. An admission, oral or written, made by the party to the course of proceeding in the same case. And does not require proof. The admission may be contradicted only the showing that it was made through palpable mistake, or that the imputed admission was not in fact made. Rule 130. Rule 130, Section 1. Objects as evidence. Objects as evidence are those addressed to the senses of the court. When an object is relevant to the fact in issue, it may be exhibited to examine or viewed by the court. Documentary evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, words, sounds, numbers, figures, symbols, or their equivalent, or other modes of writing expression, offered as proof of their content. Photographs includes pictures, drawing, stored images, X-ray film, motion picture, or videos. Section 3. Original document must be produced. Exemption. When the subject of inquiry as the content of documents, writing, recording, photographs, or other record, no evidence is admissible other the original document. No evidence is admissible other than the original document itself, except in the following cases. When the original first, when the original is lost or destroyed or cannot be produced in court without bad faith on the part of the offerer. When the original is in the custody or under the control of the party against whom the evidence is offered, and the latter fails to produce it after reasonable notice, or the original cannot be obtained by judicial local processes or procedures.